The amount of people, Blake Lively people, taking victory laps around this headline or something of the sort is so mind-boggling to me because reading is very fundamental. At least that's what my mom told me when I was growing up. But it looks like nobody is doing that. And I get it. If you're looking for a win, you can see what you want to see. Like everything looks like what you want to see for you. But let's get into it. I'm going to break it down so you don't fall prey to it if you don't already know. But you should already know.
F around and find out. F around and find out.
In order for me to explain how we got to where we got, there's been a myriad of things that have happened that explain this headline in case you're not keeping up. There are people who are not keeping up, by the way, which I'm so surprised by because I feel like I'm so engulfed in this situation. So I'm going to break it down as best as I can as to how we arrived at Blake Lively wins motion to strike Taylor Swift's text threats. Blake Lively wins motion to strike Taylor Swift's text threat allegations in Justin Baldoni legal war. To make it perfectly clear, this statement is correct. But and however, it's not what it seems. It's not going away. It's just going over there. So let's talk about how we got here. Because we all know Taylor Swift was subpoenaed, right? And then we know Blake Lively's lawyer came out shortly after that and told us how Blake is looking forward to testify, which he didn't need to because it's a civil suit. It's her suit. Testifying is not breaking news. You're meant to, like you're supposed to. It's not a criminal case where the defendant, not a defendant. It's not a criminal case where she doesn't like have to take the stand. You're going to have to testify. It's a civil suit. You're going to have to account, especially if you want the jury to fall for your bullshit, your story. You're going to have to account for a few things, right? So one of those things that got us here is this headline. Blake Lively threatened to expose Taylor Swift's text unless she publicly sided with her in Justin Baldoni feud. I don't put it past Blake Lively to do this. If you do, you know, you can have your opinions, but I believe she would do this. A lot of people are using the analogy or the idea that Blake knows Taylor is not to be effed with. Blake knows Taylor is like serious and you can't say her name. So therefore, she wouldn't try it. Except everybody is not factoring the fact that Blake is desperate. Blake has been desperate since this whole thing started. Blake's only good window for this whole situation was literally the day she, released her story, the day she broke her story, the New York Times story, and maybe 24 hours after that. That's the only window Blake had to go to sleep at night with no stress, with no worries, because she was Blake Lively, Deadpool's wife, no distress. The world was gonna crumble for her. We were all gonna bow down and help her because she's a damsel in distress. And just barely, she didn't even have 24 hours to bask in that glory. And Justin Baldoni hit her with the Uno reverse, and he happened to have evidence, something that she has not been able to give us yet. So if you're thinking she would never try to, threaten Taylor Swift or something like that, a lot of people came out to support Blake Lively since this whole thing started. Who is the one person, if you're being honest with yourself, if you're Blake stan and that's why you're here, by the way, like it while you're here, who is the one person you would have expected to be standing up for Blake, if you're honest with yourself? Taylor Swift, whether by an Instagram post, whether by bringing her to the Super Bowl, which keep in mind, she was uninvited from. And now that we look at the trajectory of things, Blake Lively cannot say she didn't go to the Super Bowl because she was trying to, stay out of the limelight, because we know she has not been doing that. So if there was a time to actually go out and step out and have support, it would have been at the Super Bowl. But we know now for sure why it never happened, because we have this February 14th phone call that Brian Friedman swore an affidavit to. And I want to reiterate, an affidavit is not something to be played with. If I had to explain to you, if in case you didn't know what an affidavit was, if I had to explain it to you in the easiest way possible, an affidavit is a legal pinky promise. It's a legal I promise. It's a legal I swear, with ramifications. If I find out it's not true, if I find out you're lying, there are actual consequences. It's not like pinky swear, then you go your way. It's a legal one. So I think that's the easiest way to make people understand what an affidavit truly is. So Brian Friedman wrote this letter to the judge, which we covered in a previous video, pretty much saying, I have, proof that Miss Lively was colluding and pretty much trying to threaten Miss Swift, right? Miss Swift is so weird. But he also 2 days ago sent this affidavit. And then we know Blake Lively's folks came back with this letter telling the judge they plan on filing a motion to strike because they think Brian Freeman is wasting the court's time. What they didn't say is, we think it's true and it shouldn't be filed in this court. They pretty much were like, it's not true, it's not happening. I mean, they categorically denied it, but they pretty much were like, we're going to come back and ask for a motion to strike, right? So after they filed that, Brian Freeman didn't even sleep on it, okay? He went right to work and wrote this back to the judge saying, Dear Judge Lyman, we write in response to the letter a motion to strike filed by the plaintiff. The premise of the motion is that I made a deliberate and shameless misrepresentation to the court and that the facts set forth in the May 14th letter are false and unfounded. That is not so. Attached here to as Exhibit 1 is an affidavit executed under penalty of perjury. He's saying if I'm lying, I'm not like put me under the jail, okay? Stating the factual basis of the statements set forth in the May 14th letter. Notably, the motion is signed not by Michael Gottlieb, whose conduct gave rise to my office's issuance of a subpoena to Venable, but instead by another attorney from a different firm representing the Lively defendants. The motion also faults the May 14th letter for being filed without evidentiary support of any kind, much less anything under oath. The opposition supplies the sworn affidavit that Lively argues the May 14th letter lacked. Finally, and most notably, the motion claims that the facts set forth in the May 14th letter are unequivocally and demonstrably false, yet it is unsupported by a sworn declaration to the effects, much less from Mr. Gottlieb. Okay, so he's saying, first of all, I'm not lying. They're saying I didn't have evidence, and they're not saying like they swear it never happened. But what I also want to note is he never said Michael Gottlieb was the one who asked for all that. They used another attorney from another firm. Again, I don't put that past them because we know they filed a sham lawsuit to obtain a sham subpoena to obtain info from Jen Abel, right? The motion further contends that the May 14th letter was improper because it does not seek any form of relief. It's irrelevant to any motion currently pending before the court and serves no legitimate purpose. Of course, the same could be said if the Lively defendant's May 13th letter, which Ms. Lively claims to have submitted as a courtesy and in which she did not ask the court to take any action. In a May 13th letter, the Lively defendants claim that the subpoena served on Venable seeks the Lively defendants' attorney communications, including those of Michael Gottlieb, with no explanation as to how they could be relevant to any parts of the claims or defenses in this litigation. Given that Ms. Lively herself, given that the motion to quash the subpoena to Venable is pending before a separate court, which is where I want you to notice, outside the court's jurisdiction, it is apparent that the May 13th letter was filed with the court for a purpose of besmirching the Wayfair parties and their counsel. A response was necessary. The May 13th letter claims in open court that my office issued a subpoena to Venable for an improper purpose rather than in pursuant of relevant documents. Accordingly, we submitted the May 14th letter to correct the record. The motion should be denied. Now, we all know the motion was not denied. What I do want to point out is Brian Freeman is saying they thought they could get this in front of you. You allowed them to do so. If I was going to respond, I couldn't possibly respond in another court because the same way they attacked me in front of everybody. It's important to know that a lawyer, any person should not be signing an affidavit if they're lying, but a lawyer of Brian Friedman's stature would definitely not have filed this affidavit if he wasn't telling the truth. So on February 14th, I received a voicemail from a person very closely linked to Taylor Swift, whom I subsequently called back the same day. Now, remember, they never went to Super Bowl together. During the February 14th phone call, which lasted approximately an hour, the speaker told me that they had been informed that J. Douglas Baldridge, counsel for Taylor Swift and partner at Venable, had received a phone call from Michael Gottlieb, counsel for Blake Lively and Ryan Reynolds, during which Mr. Gottlieb requested on Miss Lively's behalf that Taylor Swift make a social media statement in support of Miss Lively, given her absence from the Super Bowl that year. Stated that if Miss Swift failed to do so, Miss Lively would release 10 years of private text messages with Miss Swift. The individual also told me that they had been informed that Mr. Baldridge had accused Mr. Gottlieb of extortion and ended the call. Boop. I believe it. Blake is desperate. Blake was desperate. Blake continues to be desperate. This is something a desperate person would 100% do. She would not think about the fact that, oh, you don't mess with Taylor. She would not think about the consequences. She needed relief right now. She needed something. Can you imagine if Taylor had released that letter? Right now, the tables would have turned. The conversation would be different. So anyway, even after releasing the affidavit, Judge Lyman did in fact go ahead and still grant the motion to strike. But the reason it's not as simple as get it out of here, I don't want to see this, it has nothing to do with nothing. It's just that Judge Lyman cannot do anything about this. It's not his jurisdiction. Our friend Leanne, whom we've had up here before, if you guys can remember, Leanne is a lawyer. She's primarily on X, but she's transitioning to YouTube, I believe. And she's a lawyer in the UK, but a lawyer nonetheless, so she understands everything. And I explained it as well as she did, but the easiest way is we're going to read Leanne's explanation because she was tired about people bringing it up. So there were multiple letters that were submitted. We know that. The issue is not for Judge Lyman to sort out. It's as simple as that. It's like, say somebody comes to you with a problem and you quite literally cannot do anything about the problem. You don't have the power to. And even if you had the power to and you made a decision about it, it wouldn't hold. Somebody else has to make that decision. So Judge Lyman, striking that motion or canceling that out, it's not to say that Brian Freeman is lying or he doesn't believe him or Brian Freeman cannot get that subpoena. It's as simple as me in New York as a judge cannot help you. The venable subpoenas and all that stuff is being handled in DC. Once it's figured out in DC, it's gonna come over to me. But for now, if you want this, you got to go over to DC to get it. Very, very simple. The issue is not for Judge Lyman to sort out. It is for Judge Leon in DC to consider. I think Friedman knew this decision would be coming. And again, I think he did. But had it gone to DC directly, we probably wouldn't have heard about it or known about it. In order for the public to know about it, get a whiff of it, call it a PR move or what, all is fair in this battle. They started it, but because it wasn't that explosive on their end, this was much more explosive, which is why it's blowing up as it is. So Judge Lyman pretty much kicked all of them with this venable issue, with the subpoena issue, to DC. But it looks as though Justin took a loss because they were asking for something big. That's really it. So I don't want anybody to panic or think, Justin's side took a loss. Right now, Judge Lyman quite literally has no power. So I know the headline is boom, they got it granted and it looks like Brian Freeman is in trouble and Justin took a loss. No, he just has to go ask for what he wants from another man because this man quite literally can't give it to him. So I hope you all have yourselves a great weekend, a safe weekend. And I will be back live next week now that I've got my live legs back under me. Thank you all for tuning in. I appreciate it. And please make sure to like, share, and subscribe if you haven't done so. And leave me a comment. Let me know what you think about what this mess is. But I'll see you guys again on the next one. Have a good day. Bye-bye.